SJC-12606, Richard Meyer v. Veolia Energy North America.
Good morning, Mr. Howe. I'm sorry, you're Mr. Powers.
Yes, Your Honor. Chief Justice and Associate Justices may please the court. Kevin Powers for Richard Meyer. With me today is Attorney Andrew Fisher, and with us on the brief is Attorney Andrew Brody. Your Honors, in this case, justice and the equities cry out that in a situation where trial counsel did everything right, Mr. Meyer must not be deprived of due process and any access to a remedy against Veolia through application of Chapter 84, Section 18, which had its origins in sovereign immunity. Veolia is not a sovereign, and this section should not be applied to its benefit.
Should you be crying out to the legislature, considering the words used in Section 18 and the RAM case, recognizing that there wasn't a private individual in RAM, but the dicta language? The language in RAM, the plain words in the statute, should you be crying out to the legislature instead of here?
Your Honor, if the legislature saw fit to amend the statute, we would be the last to complain. But looking at the nature of the statute and the legislative intent, it was never the intent of the legislature in the first place that this notice requirement should obligate every road-injured plaintiff in the Commonwealth to conduct a detective investigation for clues as to any and all possible tortfeasors who might have some sort of obligation to do something relative to the road. By contrast, if we look at the governmental entities that are actually set forth in Section 18, and we look at town, city, county, and then through RAM, the Commonwealth.
You left out person, though, didn't you? Didn't you leave out person?
Yes, Your Honor. And person in, I'm sorry, beg your pardon.
Go ahead.
Person in the late 18th century, when the ancestor to Section 15 was first enacted, would have been understood to be the surveyor of the highways.
I thought the amicus brief does a fairly compelling job of showing that these turnpike corporations, which were private entities, were often the ones responsible for this type of work. So I didn't find that very compelling.
Your Honor, the turnpike corporations referenced in the amicus brief were created by statute, and I believe actually had an expiration date attached to them by the statute creating them. They were created for a limited purpose. They were not the sort of limited liability corporations that we think of in the modern corporate sense.
But they weren't public entities, right? I mean, your argument is there's this sort of iron curtain that separates corporations from government, and it doesn't seem like that's the way it's historically been interpreted, including by Justice Holmes.
Your Honor, Justice Holmes' remarks in the last paragraph of Fisher are in that case dicta. Indeed, in the Fisher case itself, Justice Holmes' actual holding was that the private defendant in Fisher could not avail itself of the 30-day notice requirement. And Justice Holmes does muse in that last paragraph about the possible origins of the person-to-person's language, but the ultimate holding of Fisher itself. And indeed, Fisher was then...
Can I ask also, you say that the plaintiff did everything he could. I believe this, I agree with you that the statute seems tough, but the plaintiff didn't do an internet search with the name on the hub cover, and apparently that would have produced who this was without too much work. So it's not exactly as if everything was done, was it?
Your Honor, in one or another set of circumstances, and perhaps here, a certain amount of detective work, a certain amount of searching for what Veolia's brief refers to as clues, might produce the identity.
Or a walk to the claims department of, for the city of Boston might have helped as well, and ask them what they found out in the letter, not within 30 days, but in pretty short order. I mean, I'm not saying that this, I agree with Justice Gaffer, this statute seems challenging or even harsh, but last time we talked, in RAM, both private parties and governmental entities are entitled to notice within 30 days of the defect. That seems pretty clear. I mean, we can say, oh, that was dicta, oh, there wasn't a private party in the case. I'm well aware of that, but that's what it says. Private parties are entitled to notice within 30 days.
Your Honor, I believe that all of the private parties cited in RAM for that proposition were railroad corporations, and the feature or rather, all of the cases cited by this court in RAM for that proposition were railroad cases. One of the predominant features that connects railroad corporations in regard to Section 18 to municipalities, counties, and the Commonwealth is the fact that they have total control over the way. In those railroad cases, the railroads controlled in all respects the railroads and, where relevant, the railroad access routes that would run along the railway. For example, when snow falls, when brush falls on the tracks, when the tracks need to be repaired, it wouldn't be the municipality that would take care of that. It would be the railroad. And there's an enormous difference between the responsibility undertaken by a railroad for its ways.
But that qualification's no part of RAM. What about Philippe versus Boston Gas? The one that was 4 months late as opposed to 31 days late. What about that case? Just assumes private party.
Yes, Your Honor. Your Honor, Philippe and also Bartholomew, the 128,
Right.
took the language in RAM and ran with it. And it is our position that in those cases the appeals court ran a bit too far. For example, in Philippe, Philippe held that under Wolf versus Boston Water and Sewer Commission, that the nature of the defect in the road, or what was found in the road that caused the injury, was no longer distinguishable in the same way that it had been in the Seltzer case, where in Seltzer it was held, for example, much as in the Fisher case that the amicus cited, both Seltzer and Fisher, it was held that a responsibility by a private defendant for a coal hole in Fisher or a small opening in the road in Seltzer was not tantamount to responsibility to keep the way in repair. Philippe held that Wolf had abrogated that distinction, but in fact, Wolf did no such thing. Wolf instead recognized that with regard to public governmental entities, the advent of the Mass Tort Claims Act, Chapter 258, had created a unified whole that also preserved Chapter 84, Section 15 as the exclusive remedy relative to road defects. But the case law flowing out of the Mass Tort Claims Act in conjunction with Chapter 84 pertained to public defendants. And in Philippe, the appeals court then applied that to a private defendant. And it's our position, Your Honors, that was a step too far.
Can I ask a question, and it may be just a silly one, but you bring suit against the city within 30 days, right? You file that within 30 days, right?
I don't believe so, Your Honor.
I understand.
Notice was given within 30 days.
Right, okay. Person so injured shall within 30 days or give to the county, city, town, or person obliged to keep notice of the time, place. So you provide that notice, but you don't do it to the private party. I guess I'm wondering whether there's any way that you can piggyback on the notice. You don't argue that in any way. You do give notice to the city. The city has delegated this to the private corporation. No argument could be made that by giving the notice originally, that somehow saves you.
Yes, Your Honor, and indeed it would.
But you don't argue that, right? You argue you don't make that argument, this piggyback argument, that you did give notice to the city, and that should be adequate to comply with this statute when they've delegated the task to somebody else. No? Or you do argue that? I didn't notice that was part of your argument.
I believe that we do argue that, Your Honor, in the discussion in our argument with regard to the City Municipal Code of Boston, that in the last sentence of Boston Municipal Code, Section 61120, that provision explicitly references that repairs and restorations made by the above parties, which, for example, would include Veolia, shall be made in accordance with the specifications of and under the permit from the City Public Works Department. Then, looking at Boston Municipal Code Section 61128, we see that it is the Director of Public Works who is responsible for receiving and maintaining and then acting upon notice. And so notice per the Boston Municipal Code itself is supposed to go to the city, and then the city will reach out to the appropriate private parties that may or may not have either contractual or other responsibility with the city to take care of particular problems.
Did you make that argument to the Superior Court?
I believe so, Your Honor, but I would have to check the record.
May I ask you in a different direction? I read in your brief, you state the intent of the legislature is to provide for this 30-day notice. They want 30 days notice, but why? What's the magic about 30 days? What's the ultimate goal behind this?
Your Honor, in the words of this court in Ram at pages 490 to 491, the legislature could have decided that the notice requirement is necessary to safeguard public defendants. In other words, to allow governmental defendants who have responsibility over the way to promptly facilitate the necessary repairs and take care of the problems in the roads so that we don't wind up with a situation where, for example, there's one road injury and then 45 days later there are 3 more, and then 15 days after that there's another dozen.
That could happen even if people decide they don't feel like claiming anything. They just get injured and they move on.
It could, Your Honor, but it certainly helps if the city is made aware. And indeed, looking back at the Boston Municipal Code, once the city is made aware, it's the city that per the requirements of the municipal code itself, will go about identifying who has a contractual or other.
And they in fact did that here.
I believe so, Your Honor, yes.
Just not within, do they have arguably an obligation to do it within your 30-day period?
The city? It would be great if they did. I don't believe that the Boston Municipal Code specifies that the city has to reach out to the private entity within, I don't believe that references having to reach out within 30 days.
All right, thank you.
If there are no further questions, then on the basis of those arguments and the arguments articulated on our briefs, we will ask the court to reverse the summary judgment below and to remand for trial. Thank you, Your Honors.
Thank you. Mr. Howe?
Good morning. May it please the court, Christopher Howe on behalf of defendant Appellee Veolia Energy North America, LLC. I'd like to begin by addressing this court's question about whether timely notice to the city constitutes proper notice to Veolia under the road defect statute. And I believe that the Bedard case, that is a Superior Court case, but I do believe that Bedard answers that question squarely.
Yeah, but we're not bound by,
You are not.
We're not bound, and.
That's correct, but I would also point the court to the statutory language of the road defect statute itself, which specifically requires under Chapter 84.
I totally get the plain language of the statute. What bothers me here is, so they alert the city, then for 30 days, the city is like talking to them and leading them on. Then the 31st day, after the too late, then suddenly they get the notice that it's really not the city but them. There's something sort of disconcerting about that, isn't there? I mean, you're the beneficiary of that, but.
No, I disagree. I think that the notice period that the legislature determines what is an appropriate.
They've provided notice to the city, and the city has found a way of passing on this responsibility to people like your client. Address his argument that the regulations of the city don't matter, that they don't indicate that notice to the city is enough to provide notice to you.
Well, I think the road defect statute itself provides under Section 18 that notice is required to be provided to the party obligated to maintain the way. Therefore,
The city would be obligated if they hadn't transferred the responsibility, right? It's the city.
That's correct.
So they they figure out a way of dumping the responsibility onto you. But then at the same time, they get the notice, but they don't alert anybody until after the fact that they've dumped it onto you. Go ahead. Yeah.
well, I guess I would address that by looking at the statutory purpose of the road defect statute. And I believe that the statute itself recognizes that certain municipal services may from time to time be delegated.
Totally appropriate, I get that, yeah. Mhm.
And therefore, if statutory notices are required to be provided to government entities, why should notice not also be required to be provided to private corporations like my client?
Because the government's delegated the responsibility and they've notified the government, but they don't, there's something bothersome about particularly the way this is done here. On the 31st day, they suddenly discover that it's not them. You're not bothered by that?
I think whether the notice period is fair or not is really not for this court to decide. The wisdom of the 30-day period is a
Well,
permissive
it's not whether the 30 days is fair, it's whether the one day after whatever arbitrary number has been selected is fair.
Well, again, I think it is so long as that is rational related to a permissive legislative objective, it's proper. And I don't think that those types of legislative decisions should be second guessed.
So
Let me You speak about the plain language of the statute. The way here was Sudbury Street?
That's correct.
Who was responsible to keep Sudbury Street in repair?
Where this accident occurred or the
Who was
the
responsible
roadway
to keep-
generally?
Who was responsible to, the way was Sudbury Street. Who was responsible to keep the way in repair?
In all fairness, I think that's a difficult question to answer. I think
City of Boston.
where this accident occurred, it was
But
my
that's-
client
I'm asking you
Veolia.
where the way. The statute says you must give to the county, city, town, or person by law obliged to keep said way in repair. The city of Boston is obliged to keep the way of Sudbury Street in repair. You may be responsible for the defect in the way, but that's not what the statute doesn't say, like, to notify the person who was responsible for the defect in the way. It's responsible to notify the party obliged to keep the way in repair. And so why is the city of Boston not the appropriate person to notify? It would be, I mean, and wouldn't that make legislative sense? Because everybody should know who's responsible to keep the way in repair, whether it be the Great Barrington Fire District in an earlier case or a railroad in another case, but
If I can answer that.
it's a lot
in two-
harder to figure out who's responsible for the defect in the way than it is to say who's responsible for the way.
If I could answer that in two parts, I think under the facts of this case, that section of the way was delegated by the city of Boston to Veolia pursuant to the maintenance and repair obligations imposed on Veolia under Boston Municipal Code 11-6.20.
So that section of the way, meaning that little circle that constitutes the,
The appurtenant structure and 30
but
inches.
it doesn't say the section of the way, it says the way in repair. I mean,
I
you're
think-
focusing on the plain language of the statute, so am I.
Correct.
And the language speaks about the way.
And I think it's very important when trying to discern legislative intent to read the language of the statute in its entirety. The purpose of the statute is to safeguard the public against fraudulent claims and to allow for the timely investigation and repair of alleged defects if necessary in order to prevent further accidents. So if notice is required to be provided to government entities and those municipal functions have been delegated to private corporations, why wouldn't the notice requirement also apply to private corporations like my client in this case?
Well, I mean, you agree that the legislation was not meant to be unfair. I mean, it has this provision that the notice shall not be invalid or insufficient solely by reason of any inaccuracy in stating the name or place of the residence or the time or place or cause of the injury. So they were forgiving even as to the place of the injury.
Correct.
You were to say
That
if you gave the
provision
wrong
doesn't apply to
street.
the substance of the notice.
It says
That
the place
requires
of
that
the
notice, though,
injury.
was timely, but that certain information provided in that notice may have been inaccurate.
So if they had said, I got hurt on Sudbury Street, this provision would say that's not disqualifying.
Correct, but I don't see that as the issue here. That the issue is not whether the notice that was provided to Veolia was deficient in any way. The issue is whether the notice to my client Veolia was timely
But
or
I'm going
not.
back to the legislative purpose, and it certainly makes sense to say everybody knows who was responsible for the way. And to give 30 days is not unfair. But everyone may not know who was responsible for the defect in the way. That may require further investigation, and the legislation doesn't say that. The legislation only says, whose street is this? Who's responsible for this street? And you have to notify them. It doesn't say who was responsible for the defect in the street.
Again, I think if you look at the statutory provision in its entirety, the very first line of the statute says if a person sustains bodily injury or damage in his property by reason of a defect.
I understand.
Or
That's
want of
section
repair.
15, but I'm speaking about section 18.
again,
Section
I
18
think-
did not adopt that language.
Again, I think the statute has to be read in its entirety.
the
Both
statute-
provisions read together. I think it's important, too, to note that this statute, the first version of the statute to use the phrase "person by law obligated to repair" was in 1786.
Right, I
In the
grant, I
200
grant you that a
years-
person may be responsible for a way. I grant you that.
But, Your Honor, my point is, in the 200 years since that phrase first appeared, there have been multiple revisions to this statute, including one that eliminated the comma after the word person. And I think that it's a reasonable to glean from that if the legislative meant to revise or omit that provision, it certainly had ample opportunity to do so. The fact that it did not, I think, provides insight into the legislative intent that it intended this notice period to provide to apply to both government entities and private parties.
If you went back to I've gone back in time too. In 1894, it included snow and ice. Correct?
Yes, and it includes snow and ice
And
today.
it gave only 10 days for snow and ice.
Correct, and that reflects,
Who would be responsible for an unnatural accumulation of snow and ice? Would it be the person who put it there, or would it be the town who was responsible for the way?
I'm not sure who could put the snow and ice there.
A person could be shoveling off the sidewalk and throw it into the street.
I don't know the answer to that question. I didn't.
But then, who would be responsible to get notice if there was an unnatural accumulation of snow and ice on a street? Would it be the person responsible for the way, or would it be the person who dumped the snow onto the street?
I suspect it would be the person responsible for the way, although they would likely be one and the same person in most instances. So,
And if it turned out to be the shop owner who dumped all the snow in front of her shop and put it in the street, would that be a wrong assumption? Then would you have to notify that shop owner and have to determine which shop owner did it within 10 days?
I don't think that the statute would impose that obligation under those specific circumstances. I would just remind the court that it has held that arguments regarding hardship are appropriate to consider with respect to the enactment of statutes, not the interpretation of existing statutes. I do think.
I'm not referring, I'm just trying to see whether or not the legislature meant to be so unfair as you describe it to be, especially when they're somewhat forgiving with regard to the nature of the notice, including the place of injury.
Well, I do believe that issue has been judicially examined and decided by this court on multiple prior occasions. This case is controlled by this court's decisions in Dickey, Murphy, Wolf, and Ram, and I do think that case law is very clear that the provisions of the RDS, including the mandatory statutory notice, apply to both government entities and private parties like my client.
Was there a distinction, I've read those cases, but not with this point in mind. Was there a distinction in those cases between the way and the defect? In this case, there's difference. The city is responsible for the way, except for this manhole cover, which you're responsible for. Did that distinction appear in those other SJC cases?
I don't recall that distinction being made.
So that does matter then. We're in a gap if it wasn't made. And can I ask another question? How would they have, say they did, your name, I agree, your name was on the manhole, so there was a way of figuring this out. But a lot of manholes, I assume, have nothing on them. How does somebody figure out who's responsible, particularly when the city is not all that forthcoming?
Well,
Because the city really knows,
First,
the city knows who's responsible for these things. They have contracts. They can figure it out within 30 days. I don't know if the guy riding the bike can figure it out in 30 days, particularly without help from the city.
Well, first, I'm not sure I agree that the city was uncooperative or unhelpful in
I'm
this
happy,
case.
it did happen on the 31st day. I always find that,
It did, but although one of your colleagues raised the fact whether you could, you could have gone down to City Hall in person to ask, here's a picture of
but
the
what's the
utility
difference, what's the
cover.
difference between calling on the phone and going down in person?
Well, if someone was uncooperative, you could have asked to speak to a supervisor.
Well, how would they even know if the person was uncooperative? She seemed very cooperative. She just didn't find it until the 31st day.
The affidavit that was submitted by Attorney Fisher in this case indicates that, he's an experienced attorney. He's handled these types of cases before.
I know, but we have to decide every one of these, not just this particular one.
And I understand, and frankly, since the statute itself does not provide for reasonable ascertainability or impossibility, I really think that those issues are irrelevant in some sense.
But we try to make the legislation make sense, right? I mean, you're right. We want this fixed quickly, so that may be why we have a 30-day rule.
And I think if that's the case, then it's the legislature's responsibility to make those changes, not this court.
But doesn't it make the most sense to interpret the statute the way the chief did, which is you notify the city or the private owner? In a turnpike, in the old days, it would be a private owner. I get that. But you don't figure out who's responsible for the little defect part of it. That takes more time. But if you notify the city within 30 days, they want to get that pothole fixed because they don't want their constituents hurt.
Again, I think the statute's intent and purpose is to provide for the timely investigation and repair of alleged defects in public ways. I'm not sure why that wouldn't apply to both government entities and private parties equally. Without such timely notice, private parties like Veolia would be in the position of having to investigate and defend against defect-based claims long after an occurrence of, an injury when significant changes could have been made to that accident site. And I think that's the statutory purpose, is to safeguard the public against fraudulent claims and to allow for the timely investigation and repair of such claims to prevent further injury.
Assume that's true. You really haven't answered the appellant's point, though, about why is it, you've got a particular regulation that he referenced, maybe it was 628, I'm not sure, and you've got the responsibility of the city. So he takes the position that notice to the city is sufficient to satisfy the statute of notice to the person, even putting aside the issue of the notice going to the person or entity that's in control of the public way. Put that aside. You were asked the question by Justice Kafka, and the appellant made the argument, but what's the answer to why isn't notice to the city sufficient, since they've obviously delegated that portion of the way to your client?
Once again, without engaging in circular reasoning, the statute itself provides that notice has to be provided to the party obligated to maintain the way. In this instance, on the facts of this case, Boston Municipal Code 11-6.20 makes clear that Veolia was responsible for that area where the plaintiff alleges that he was injured.
So your position is that this bicyclist would have to know the precise place of the injury and the precise cause of the injury. That is that the bike hit a manhole which was improperly stationed, and that it occurred at that very location.
Yes, and I would add that as the record indicates, that my client's identity was was reasonably identifiable. The manhole cover, The plaintiff alleges that his bicycle accident occurred as a result of an uneven utility cover that was located on the roadway. That utility cover very clearly identified the responsible party as Trigen Boston. It should have been immediately apparent that that was not the city.
But I guess my question is, the legislation explicitly says that notice is not invalid if you are in error as to the place or cause of the injury. But you're saying, actually, no, you would have to know the precise place and cause of the injury, because only then would you be able to give notice to the precise person responsible, which is Veolia. If you did not know that you had hit that manhole, if all you knew that something on that road caused me to fall, and you got it wrong, why would the legislation say that the place or cause of the injury may be forgiven, but you're saying, well, you actually would need to know the precise place or cause in order to give the proper notice?
In this hypothetical,
It's not hypothetical.
well,
I mean, he happened to know the precise place and cause, but assume for the moment that he did not. I hit something on Sudbury Street, and I flopped. That would not be, according to this, you'd be forgiven for not knowing where on Sudbury Street.
right, but the claimant in that scenario would still be statutorily required to provide 30-day notice.
To
Right,
Veolia.
but who, to who?
To Veolia.
Well, again, I think,
And you would only know that you would be serving Veolia if you knew the precise place and cause of your injury, which was the manhole and not the street.
if there was no identifying marks on the utility cover, I think that's what we're getting at, and so the plaintiff was not able to determine who owned that utility cover. I think it would be logical for the plaintiff to provide notice to the city in that circumstance. However, presumably he would have photographed the area, and then the city would be able to determine from those photographs that that was an area that had been delegated to another private party, Veolia in this case, but in any other case, whoever it would be, and that would enable the plaintiff to provide the proper statutory notice.
But under your analysis, if the manhole cover was blank, without the manufacturer or company involved, the plaintiff would still be out of luck, right?
Under these facts?
If we strictly apply the statute and the manhole cover is blank, does the plaintiff still lose?
If notice was not provided within the 30-day period?
Right.
Yes.
Okay, thank you. Morning break, one more.
I'm fine either way.